Yeah. So maybe they'll flood us.
And if anybody's coming from Interport, they'll come from this, because it's at 5.
Right.
After
I see John Boyle.
John Boyle. He's just here to harass you.
That's it. He's already done that.
Good afternoon.
And there's some overlap. So
Can you hear me?
that is good.
Good afternoon. My name is Peter Teachout. I'm a professor here at Vermont Law School, and I will introduce Judith Dillon, who's the president of the Vermont Bar Association, who will make introductions, and then we will get started this afternoon. Thank you all for coming.
Thank you, Professor Teachout. Welcome to the 9th Annual Celebration of Constitution Day. This is a collaboration between Vermont Law and Graduate School, the Vermont Bar Association, and the Vermont Judiciary. As Professor Teachout indicated, my name is Judith Dillon. I'm proud to serve as the president of the Vermont Bar Association. I'm also proud to be an alumna of Vermont Law School, then known as Vermont Law School. I have the honor of moderating today. Yay! I've the honor of moderating today in front of this, or before this esteemed panel, and you're all in for a great treat. Constitution Day commemorates the signing of the U.S. Constitution on September 17th, 1787 by the delegates of the Constitutional Convention in Philadelphia. The purpose of Constitution Day is to give all of us an opportunity to reflect on the foundations of our legal system and the role of the rule of law, and to come to know it a little bit better and understand it, and which will help us to protect, honor, and uphold it. This theme for this year is Voices of Democracy. That's the same theme that the American Bar Association had for its Law Day. And this past spring, the Vermont Bar Association and members of the judiciary traveled throughout the state with practitioners volunteering to present courses and programs in schools throughout the state to supplement their civics and government education. It was great fun. I think the highlight was likely Rutland County, as always, putting on a mock trial involving Barbie and Ken, involving a trespass and damages to Barbie's dream house. So it was a great opportunity. I participated, the chief participated, as well as Terry Corsones, who's in the audience, and Alfonso Viega, who's also in the audience. It's an opportunity for practitioners to get out in the communities. I'd like to use this opportunity briefly to encourage you as law students to take advantage of the events that the Vermont Bar Association will be putting on right here at Vermont Law and Graduate School. On October 22nd, there's going to be a panel of Vermont practitioners, all of whom are alumni of Vermont Law School, who will tell you about their practices, tell you what it's like to practice law. There'll be an opportunity for questions and answers. It's a great opportunity to network, to get to know people, and to make connections. There's also going to be a bankruptcy CLE on November 22nd. That's free to Vermont law students. All you need to do is register through the Vermont Bar Association. And there's going to be a fun run, a race judicata run in Montpelier later on this fall as well on November 2nd. So I'd encourage you to participate in all of those events as well as the thaw in January. Now, let's turn to the purpose of today, Constitution Day, and the Constitution Day celebration. I'd like to introduce to you our esteemed panel. To my immediate left is Chief Justice Paul Reiber. The Chief is a graduate of Hamden.
Paul is.
Yeah, Paul.
Yeah,
we're old friends. It was funny when I was writing this little blurb, I'm like, what is his first name? I forgot. Okay, so now it's drilled in. Chief Justice Paul Reiber is a graduate of Hampden-Sydney College in Virginia, then went on to graduate from Suffolk Law School in Boston. He worked in private practice in Rutland at the law firm Kenlin Schreiber and Facey. He was appointed to the Supreme Court as an Associate Justice by Governor James Douglas in 2003. The next year, he was sworn in as Chief Justice. The Chief's discussion and topic for today is the states as voices of democracy, the anti-federalist perspective. Next to the Chief is Associate Justice Harold E. Eaton, Jr. He was born in Windsor, Vermont, and graduated from the University of Vermont and Vermont Law School. Before appointed to the bench, he served as Deputy State's Attorney, then Chief Deputy State's Attorney in Chittenden County during the early 80s. He then worked in private practice at his firm Eaton & Hayes in Woodstock. In April 2004, he was appointed to the Superior Court by Governor James Douglas. 10 years later, in 2014, Governor Peter Shumlin appointed him to the Supreme Court. The topic of his speech will be dangerous speech in the internet age. Next to Justice Eaton is Judge Heather Gray. She received her Bachelor of Arts from Notre Dame, then took advantage of the clerkship path to become an attorney in Vermont. She worked as a prosecutor and as a private attorney in Burlington before working for the Department of Sheriffs and State's Attorneys. She was sworn in by Governor Phil Scott in 2022. She currently presides over the Windsor Criminal Division. Her presentation is titled, Having Your Voice Heard, Challenged with Civility. Next to Judge Gray is Judge Daniel Richardson. He's a graduate of Ohio Wesleyan University and Vermont Law School. Are you noticing a trend here? Folks who go to Vermont Law School have a great opportunity for success. Success, I don't know about that. That was my experience, but
We'll take a poll.
Yeah, we'll take a poll. Success and leadership opportunities in Vermont. So you have one justice right before you and a judge, is my face red, judge who went to Vermont Law School. And as you all know, Heather Gray served as lieutenant governor several years ago, and she was a recent graduate of Vermont Law and Graduate School. Molly Gray. I'm flustered. Sorry about that. Sorry about that. Yeah. Sorry about that. Back to Dan Richardson. That's where we were. Before becoming a judge, Judge Richardson worked for years in the Montpelier general practice firm of Tarrant, Gillies, Richardson, and Shems. He also taught for years at Vermont Law School. He served as the city attorney for the city of Burlington right before he was sworn in as a Superior Court judge in 2022 by Governor Scott. He currently presides in Windsor and Orange County units, serving in the family, civil, and criminal divisions. His topic is the tragedy of Narcissus, the interplay of technology, libel, and First Amendment freedoms. Finally, Professor Peter Teachout. As you know, he's on the faculty of Vermont Law Graduate School. He was a graduate of Amherst College, Harvard Law School, and received a master's from Sussex University in England. He has taught, in addition to Vermont Law and Graduate School, he's taught at Tuck Business School, University of Washington, and Harvard. His topic today is threats to democracy and the Constitution. So our first topic and presenter will be Chief Justice Reiber. Thank you.
Thank you. Thank you. Thank you very much, Judith. Thank you for that twist in your presentation. This is a more open discussion than I had anticipated. Let me make one housekeeping sort of comment to start. Some of you may know, I don't know how it was advertised here, but there are 2 chapters of an institution in the state called Inns of Court. And Inns of Court is a traditional, originally British institution for training young lawyers. We have a chapter in the southern part, and our chapter is actually meeting here today with all of you at the same moment that we're making these presentations on Constitution Day. And immediately following the presentations, pizza is coming in. There's a wonderful cake that our hero, Terry Corsones, who's the court administrator for Vermont, has baked that's over there in celebration of Constitution Day. And the Inns of Court meeting that will follow immediately after this presentation, for all of you who can stay, as I say, we'll have free pizza for anybody who wants it, cake, and then we're going to have an open sort of discussion, just a Q&A. There's no real structure to it. I've asked my law clerk, who's here, Chris Mullaney, to come up and sort of moderate it. So we're going to do that when this is finished, and I'll get started with my piece now. So good evening, everyone, and thank you for being here. To begin tonight's discussion, I want to take us back to the time of the ratification of the Constitution, to the debates between the Federalists, those like James Madison and Alexander Hamilton who supported ratification, and the Anti-Federalists, those who opposed ratification. I'm going to look at the Anti-Federalist criticism of the Constitution's proposed federal judicial branch and at the debate over the parameters of federal and state authority. So my thesis this evening is that by examining the give and take between the Federalists and the Anti-Federalists, we can better understand the function of state court jurisdiction as an independent constitutional structure bearing on fundamental principles of separation of powers and checks and balances, not only within the states, but implicated in the federal system as well. I also hope to remind you all that many of the constitutional debates that we are having today are the latest installments in centuries of disagreement, and perhaps that history of disagreement and the fact that our nation has persisted and even thrived despite that disagreement may be of some comfort. So to begin, who were the Anti-Federalists? In short, that is the name that has been given to those who opposed ratification of the U.S. Constitution in the late 1780s. And they include some of the most prominent political figures of the time, including Richard Henry Lee, the president of the Continental Congress, George Clinton, the governor of New York, and George Mason, a Virginia delegate to the Constitutional Convention, whose work helped form the basis for the Bill of Rights. While their names may not be celebrated in the same way as those of the Federalists, their writings are worthy of study and their accomplishments worthy of celebration. To focus specifically on their critiques of the Constitution's proposed judicial branch, the Anti-Federalists feared that the federal judicial power would encroach on that of state courts, eventually leading to their destruction. In the words of the prominent anti-federalist Brutus, thought to be New York Supreme Court Justice Robert Yates, the federal judicial power, he said, will operate to effect in the most certain but yet silent and imperceptible manner what is evidently the tendency of the Constitution, an entire subversion of the legislative, executive, and judicial powers of the individual states. And George Mason expressed the same sentiment, arguing that through its expansive jurisdiction, the federal judiciary would impair and ultimately destroy the state judiciaries, and by the same principle, the legislation of state governments. The Anti-Federalists also believed that through the aggregation of power in essential federal authority, the Constitution as drafted would lead to the loss of individual liberties and erosion of state sovereignty. They wanted a more decentralized form of government with protection for individual rights and stronger states. They believed that the Constitution created a monarchical presidency and left insufficient power in the courts, that it offered no guarantee of juries in civil cases, or that criminal case juries be local, and that it would result in an out-of-control federal judiciary. They saw federal jurisdiction as a danger to individual liberties and the sovereignty of the states themselves. They feared that as federal power grew, more cases would be taken to federal court than state, thus reducing the weight of state judiciaries. Because federal courts would interpret the Constitution, they thought the federal courts would accrue more power as they allowed federal power to expand at state expense. Many of the Anti-Federalists were small farmers who subscribed to a libertarian tradition, a distrust of centralized power, and a preference for local authority. They anticipated a threat to personal liberty from the concentration of power in the federal government. Even the judiciary, they proposed, was to be under popular control, with each town to choose its own judges. Their perspectives derived, at least in part, from the original Articles of Confederation, a weak central government, simply a joining of states based upon an agreement. In short, they were a movement in support of individual liberties and opposed to ratification. The Federalist response to these critiques was essentially to dismiss them as unwarranted, given the constitutional role reserved for states and state courts. Hamilton argued the Constitution needed no Bill of Rights because the states, through their courts, would stand as sentinels, that's the word that he uses, watching over the rights of the people. Although the Bill of Rights was added to protect individual rights of the people, one authority, Judge Jeffrey Sutton of the Sixth Circuit, says it did not, in fact, dilute the Constitution's guarantee of states as the first line of defense. Famously, in Federalist 45, Madison noted, the powers delegated by the proposed Constitution to the federal government are few and defined. Those which remain in the state governments are numerous and indefinite. They are those that concern the lives, the liberties and properties of the people, and the internal order, improvement, and prosperity of the states. In Federalist 39, Madison referred to the Constitution as a hybrid of a single national state and a confederation of single states. And in Federalist 78, Hamilton described the federal judiciary as the least dangerous and weakest branch of government. And while he acknowledged that the necessity of uniformity in the interpretation of national law would result at times in the subjugation of state courts to federal ones, he argued as a general matter that the state courts would retain the jurisdiction they now have. So how has this played out across American history? In my view, the Federalist response to the critique has mostly been proven correct. While federal courts have exclusive jurisdiction in certain limited areas, the state courts have otherwise retained the jurisdiction they held at the time of the founding. Congress has never granted federal courts the full scope of jurisdiction authorized under the Constitution. Intrusions on the authority of state legislatures have occurred most prominently during the Lochner-era court, but the modern federal judiciary has developed various doctrines that limit its own jurisdiction. One example is abstention, which requires federal courts to refrain from deciding federal constitutional claims when a case might turn on questions of state law. The rationale behind that doctrine is constitutional avoidance and comity to avoid needless conflict with the states as fellow sovereigns. Meanwhile, state courts have asserted and guarded the right of independent judicial review of state constitutional provisions. While state courts cannot interpret their constitutions to provide fewer individual rights than analogous provisions of the federal Constitution, they are free to provide greater rights. Thus, the system is operated to expand, not limit, individual freedom and rights. This essential agency of state courts is precisely what the Federalists envisioned. Take, for example, Article 1, Section 9 of the Constitution, which guarantees that habeas corpus not be suspended except in cases of rebellion or invasion, and permits state courts to prevent federal lawlessness through the state common law writ. As Hamilton explained in Federalist 28, if the federal government invades people's rights, Americans can turn to the states as instruments of redress. There, he says, if their rights are invaded by either federal or state government, they can make use of the other as the instrument of redress. This dynamic is evident, at least implicitly, in other provisions of the Constitution. For all the relative success of the system, it remains admittedly fragile. To preserve the delicate balance, states and state Supreme Courts must continue to assert their authority to protect individual rights. As Justice Brennan famously argued, state constitutions, too, are a font of individual liberties, their protections often extending beyond those required by the Supreme Court's interpretation of federal law. Judge Sutton has made much the same argument that a chronic underappreciation of state constitutional law has been hurtful to state and federal law and the proper balance between state and federal courts in protecting individual liberty. Maintaining that balance remains the key to achieving this goal. In conclusion, I commend the perspective of the Anti-Federalists as a vehicle to gain a more complete understanding of the importance of state constitutions in our democratic structure. State constitutions, then as now, are a necessary component. Federalism, shared power with the states, is consistent with this historical perspective. Thank you very much.
Thank you, Chief. So why do we protect speech that threatens the very existence of democracy? Let's start at the beginning with our Constitution. As you all know, the First Amendment states that Congress shall make no law abridging freedom of speech. And from a libertarian perspective, this would lead to relatively easy cases for judges. No law means no law. And some justices have thought that should be the end of it. In his dissent in Dennis versus United States, Justice Black stated that he believed the Constitution required a governmental policy of unfettered communication, even if this creates dangers. But not all justices have agreed to that libertarian approach, and instead the Supreme Court has carved out certain types of speech that is not protected. For example, obscenity, defamation, child pornography, and incitement to imminent lawless action are all unprotected forms of speech. Specifically looking at dangerous speech, there was the bad tendency cases of the early 20th century, which was then in turn replaced by the clear and present danger test. The court described the relevant question for that test in Schenck versus United States as whether the words used are used in such circumstances and are of such a nature as to create a clear and present danger that they will bring about the substantive evils that Congress has a right to prevent. In Brandenburg versus Ohio in 1969, however, the court turned to the imminent lawless action test. And under this new test, the government may only forbid speech when that speech is directed to, inciting, or producing imminent lawless action and is likely to incite or produce such action. There's three elements to this test. Number one, does the speech explicitly or implicitly encourage the use of violence or lawless action? Second, the speaker must intend that the speech will result in the use of violence or lawless action. And thirdly, the imminent use of violent or lawless action is the likely result of the speech. The reasoning in creating these tests, the justices balanced the vital role that debate plays in American democracy against the safety concerns to democracy. The idea to balance these competing interests is based on the reasoning that existed pre-Constitution, that debate is critical for truth and democracy. For example, philosopher John Milton encouraged, "Let truth and falsehood grapple, because whoever knew truth to put to the worst in a free and open encounter." In other words, he believed that the truth would win in any battle between truth and lies. Similarly, in his essay on liberty, John Stuart Mill argued that it is only by the collision of adverse opinions that the truth has any chance of being supplied. In line with these philosophers' theories, one of the most frequently recurring reasons put forward in cases for why dangerous speech should be protected is that more speech encourages democracy. Even dangerous speech about lawlessness and overthrowing our government allows debate about these ideas. And so the argument goes, we should protect dangerous speech because debate is the cornerstone of democracy. For example, in his concurring opinion in Whitney versus California, Justice Brandeis described free speech as a prerequisite to discussion and stated that free speech was the antidote to the dissemination of noxious doctrine, or in other words, debate rather than suppression helped to sterilize dangerous ideas because the fitting remedy for evil counsels are good ones. Similarly, in Snyder versus Phelps, the court stated that the First Amendment reflects a profound national commitment to the principle that debate on public issues should be uninhibited, robust, and wide open, because speech concerning public affairs is more than self-expression. It is the essence of self-government. These justices also argued that while this speech can lead to dangerous actions, democracy, debate, and the truth justified allowing dangerous speech. In his Whitney concurrence, Justice Brandeis argued that while speech can lead to dangers, and that the government can justifiably be concerned about those dangers, fear of serious injury cannot alone justify suppression of free speech and assembly. Men feared witches and burnt women. Similarly, in Justice Holmes' dissent in Abrams versus U.S., he argued that while it might be a natural instinct to quash dangerous speech, the ultimate good desired is better reached by free trade in ideas than persecution for expression of opinions. And the best test of truth is the power of the thought to get itself accepted in the competition of the market. Adhering to this reasoning, the test the justices created is very restrictive on the government. It protects dangerous speech right up until the critical moment between speech and danger of lawless action. We forbid only dangerous speech that will imminently incite lawless action. The internet has changed everything. The venue for political debate has changed dramatically over the last few decades. How the framers and the Supreme Court justices deciding cases like Brandenburg, Whitney, and Dennis thought about debate probably didn't include predicting that the internet or social media would exist. In a recent case, Wells versus Rice, it was stated, "It is notoriously difficult to determine when speech descends from political speech, even impassioned speech, to incitement. But one thing is clear, the mere tendency of speech to encourage unlawful acts is not a sufficient reason for banning it. Speech that fails to specifically advocate for listeners to take any action cannot constitute incitement. Even speech that advocates for future violence or unlawful action is constitutionally protected if the actions are to take place at some indefinite future time. Therefore, the threat of lawless action must be both imminent and likely. The Constitution does not permit a state to forbid or prescribe advocacy of the use of force or of law violation, except when such advocacy is directed to inciting or producing imminent lawless action and is likely to incite or produce such action. Even a protester who yells, "We'll take the fucking street again," after being ordered off the street by police as a part of a large and non-compliant crowd, is protected by the First Amendment. There must be specific advocacy of a specific action at a specific time. But that leaves unanswered several questions. How likely must the lawless action be? What criteria should be used in the risk analysis? What does imminent mean? Imminent and likely both require a risk analysis. What are the tests for these? Advocacy of violence or unlawful action is not enough. It must be an intent to incite, and it must be imminent and likely. But what are the tests for those? So that begs the question, does the current test of imminent incitement of lawless action still work? Three areas where I see potential critical issues as we consider our current test for dangerous speech on the internet are, number one, the ability to incite violence is no longer restricted to a specific location or moment because of the internet. YouTube, for example, now provides an opportunity for dangerous speech to reach millions of people, both at the moment when the speech is occurring and for months and years afterward. Number two, the internet is as good at disinforming people as it is at informing them. There's plenty of speech on the internet, but truth is not always prevailing. Instead, social media algorithms are showing people what they want to see, what they agree with, and what makes them outraged. Number three, new public forums are owned by companies that have their own incentives. There's a difference between allowing individual access to a public forum owned by the government, an entity restricted by the First Amendment, and a public forum owned by a private entity with its own motives. In a recent Supreme Court case entitled Packingham, the court showed its difficulty in dealing with the internet and social media issues by stating, in part, a fundamental First Amendment principle is that all persons have access to places where they can speak and listen, and then, after reflection, speak and listen once more. Today, one of the most important places to exchange views is cyberspace, particularly social media, which offers relatively unlimited low-cost capacity for communication of all kinds to users engaged in a wide array of protected First Amendment activity on any number of diverse topics. The Internet's forces and directions are so new, so protean, and so far-reaching that courts must be conscious that what they say today may be obsolete tomorrow. Here, in one of the first cases the court has taken to address the relationship between the First Amendment and the modern Internet, the court must exercise extreme caution before suggesting that the First Amendment provides scant protection for access to vast networks that the statute here enacts a prohibition to. Social media allows users to gain access to information and communicate with one another on any subject that might come to mind. With one broad stroke, North Carolina bars access to what for many are principal sources for knowing current events, checking ads for employment, speaking and listening in the modern public square, and otherwise exploring the vast realms of human thought and knowledge. Foreclosing access to social media altogether thus prevents users from engaging in the legitimate exercise of First Amendment rights. And here, the law prevented sex offenders from using the internet. And the court said, even convicted criminals, and in some instances, especially convicted criminals, might receive legitimate benefits from these means for access to the world of ideas, particularly if they seek to reform and pursue lawful and rewarding lives. The state may not enact this complete bar to the exercise of First Amendment rights on websites integral to the fabric of modern society and culture. And we are back to more speech, and more access to speech remains the guiding principle undergirding the First Amendment protections. Thank you.
adding on to that, and the First Amendment also provides the right of the people to peaceably assemble. And when I was starting to look at this presentation, what I really jumped on was the matter of peaceably. And while there can be restrictions, or while that the restrictions are limited to that abuse, meaning if people incite violence or, I think I need more of this, because I will tell you in the courtroom, I've been told I'm very soft-spoken, and I feel like I'm yelling. I don't want to yell at people, but I feel that way, so I'm just going to move it a little closer.
Yell away.
Yell away, and it would be okay. But it really struck me, or what I really focused on, and that's why I said the challenge with civility is the fact that we want people to have these rights, the free speech, to the right, or not want, we do have these rights, and what a great right they are to be able to speak up, and even if they might be your speech or what you are assembling or what you are protesting offends others, as long as you do it in a way with civility, that you're not inciting violence or breaking laws otherwise, that's all protected, no matter how someone else may believe that's offensive, and how great that is, because you don't have to fear that you're going to have a certain point of view that if you speak out about it, that you would be get in trouble for, and it, in my opinion, then also allows us to have that open dialogue of how change comes about, that we have these differences of opinion. There's multiple cases I was going to touch on, but one, I think it was Justice Jackson some time ago in West Virginia versus the West Virginia State Board of Education versus Barnett had stated, the test of its substance is the right to differ has to do things that touch at the heart of the existing order. And that really struck me as one, when we're speaking out either free speech or the right to assembly, that the protest usually is something, it's not something that is kind of benign, it's something that's going to impassion people and get people to have different points of views, and that again, no matter how offensive it might be to someone else, that it's going to be protected as long as you do it in a civil way, as long as it's not inciting violence or breaking the law. There is a recent decision that came out of, well, it's had quite a bit of a past, but recently it's a decision from Louisiana, federal court in Louisiana. It had come back down from the Fifth Circuit. It's Ford versus McKennison, which in that case, there had been back in July of 2006, some protesting after a young man had been killed in police custody. A young African-American man had been killed in police custody, and there had been some protesting concerning that by a movement, by the Black Lives Matter movement. An officer during that protest had been injured. Someone had thrown some sort of concrete, but it was an unknown person who had thrown some object at him that had injured him. He had brought suit first against the movement and against McKennison, who he believed was the organizer of this protest. And the thought was that by organizing it, or his claim was that by organizing it, he had allowed that he would be liable for the negligence or the acts of others that led to his injuries. It was found that it couldn't be said that McKennison had organized it, but also that there was nothing about that McKennison had not engaged in any sort of violent behavior, nor had he instructed others to be violent, nor had he incited others to be violent, and that he could not be, based on that, liable for the injuries caused by others at that protest. And in there, the quote from notes that the First Amendment precludes punishment, whether civil or criminal, unless the speaker's words and were intended, not just likely, to produce imminent disorder. So this touches right on upon what Justice Eaton had just spoke about. It's not simply that they were likely or there's a possibility, but they were intended. So it looks at the subjective rather than the objective attempt that someone would have. And again, one of the main reasons for doing that, or to look at that way, is to not have that chilling effect that people are going to be afraid, that they're going to be afraid to speak out, that they're going to be afraid to come together in protest in a way against something that they want to have impact on. In order to prevent that chilling effect, it has to look at the subjective intent and not just objectively. Of course, multiple times when people get together in large groups, there are things that can happen, but if there's no actual intent to cause that, you're going to be protected under the First Amendment. That was essentially, so I think I was the quickest, and I think that I will give my time to Judge Richardson. Thank you.
All right. Thank you, Judge Gray. Let us, like the Canadian philosopher Marshall McLuhan, consider the myth of Narcissus. In the story, Narcissus, a handsome and winning lad, is strolling through the Greek forest one day when he catches a glimpse of the most beautiful thing he has ever seen. The image is transformative. In that instant, the old world, with all of its distractions, falls away. Narcissus decides that there is nothing more important to do than stay right there, stare at the image, and wait for updates. While some of us might laugh at Narcissus for falling in love with his own reflection, McLuhan reminds us that Narcissus never realizes that he's looking at himself. He is merely transfixed by the beauty and easily entertained in the low standard days of entertainment before cat videos. The punchline is that we are all Narcissus because all technology is an extension of us. When we stare at our smartphones or spend hours scrolling through feeds, we are staring back at ourselves. In this electronic age, we are surrounded and mesmerized by these extensions. This confusion is only going to increase as the extensions grow more complicated. With AI, if we can prompt it, we can see it. This is already occurring. Last fall, I met a group of computer science students at the University of Nevada, and they admitted that when they get lonely, they start a conversation with ChatGPT. Just as Narcissus was eventually transformed into a flower, technology changes the way we think and perceive the world. We do not recognize these technologies as extensions of ourselves, and as a result, we do not always recognize the best way to respond. In this brief presentation, I'd like to build on this idea with 3 brief examples of cases where technology has transformed an issue and raised a constitutional consideration. My goal is to raise some of the questions that you and your peers will answer in the coming years. For my first example, let's take the fact that taking a picture of yourself with a ballot is not just a geeky thing to do on Election Day. It is illegal in 14 states and subject to criminal penalties. These include states across the spectrum from New York and Massachusetts to North Carolina and Texas. Why is it against the law? To understand, we have to go back in history. Originally, casting a ballot was a public spectacle. People cast highly visible ballots into glass jars as others watched. Again, no cat videos. Once political parties got organized, they used open balloting to enforce party discipline and to track voters. By the late 19th century, however, this process had devolved into voter intimidation and fraud. So good government reformers enacted changes that pushed voting into private spaces where voters could express their own conscience. Thus, our modern conception of voting. Enter social media and the selfie. With the advent of cell phones, people began to express their civic enthusiasm by posting selfies with their ballots. The latest data suggests that 1 in 10 of the voting population has posted such a selfie. I'm looking at all of you. Now, the system which had survived for 100 years and had presumed these questions to be largely resolved, and that had what many believed to be the gold standard of voting, is suddenly challenged. Last month, a North Carolina voter, with the help of former Vermont poverty law fellow Jay Diaz, filed a lawsuit to overturn the North Carolina ballot selfie law. Diaz and the voter contend that taking selfies is a constitutionally protected expression of First Amendment rights. Do we have a First Amendment right to take a selfie at the ballot box? The case of Rideout versus Gardner from the First Circuit generally affirms this right, but raises some of the challenges associated with this question. In Rideout, 3 New Hampshire residents challenged a similar New Hampshire selfie ban. The district court applied strict scrutiny to the law and found that while the state had a compelling interest in preventing vote buying and voter coercion, the evidentiary record and legislative history did not show these issues to be valid concerns in this case, and did not show how a more narrowly tailored law would not have been superior. On appeal, the First Circuit disagreed with the level of scrutiny. Because a ban on photographs with ballot is content neutral, the court ruled that intermediate scrutiny applied as a regulation and had nothing to do with what had been said, but rather serves the governmental purpose, unrelated to the content of the expression. Under this test, however, the state would only need to show that the regulation is narrowly tailored to serve the government's controlling considerations, but it need not be the least restrictive. Even under this lower scrutiny, the First Circuit found that the New Hampshire law was unconstitutional. In particular, the court noted digital photography, the internet, and social media are not unknown quantities. They have been ubiquitous for several election cycles without being shown to have the effect of further vote buying or voter intimidation. As the plaintiffs note, small cameras and digital photography have been in use for at least 15 years, and New Hampshire cannot identify a single complaint of vote buying or intimidation related to a voter's publishing a photograph of a marked ballot during that period. What Rideout and the North Carolina case demonstrate is that the old reason for making ballots secret is not the compelling concern it once was. The widespread use of selfies was not intended to be and has not become a vehicle for party bosses to commit fraud. That era, fortunately, appears to be over. The new behavior is a result of a change not only in technology, but in resulting attitudes. We take selfies in part because they are cheap, easy to do, and instantaneous. They have become embedded in a culture of sharing. 40 years ago, we did not take pictures of our ballots, but we also did not take pictures of our meals and send them to friends. While there are other factors at play here, it would serve the courts well to keep in mind how the technology has changed our perceptions and beliefs. This is not to say the issue is resolved or closed. We don't know how these issues will evolve. What if we capture the image of another voter's ballot? What if the reason we are taking these photographs is not to celebrate voting, but in furtherance of our conspiracy theory? What if we post these photographs and invite others to scrutinize and challenge those in line? What if we use these photos to spread disinformation? In this respect, the context of government regulation is likely to be stronger and sustainable if it addresses real-time problems as they are identified and as they emerge. In Minnesota Voters Alliance versus Bansky, the U.S. Supreme Court notes, "We do not doubt that the state may prohibit messages intended to mislead voters about voting requirements and procedures." The next issue I'd like to discuss is the emerging issue of social media and the question of public forums. The First Amendment restricts the government from regulating the content of speech. Their limitation is nuanced by distinctions in the nature of the regulation, content-based versus content-neutral, and the nature, time, and type of communication. One of the most important qualifications is the forum where the speech takes place. In traditional public forums, there is an expectation of open and free expression. In limited public forums, less so, and in private forums, none. But once more, technology has thrown us a curveball. With the internet, and more particularly social media, the ability to craft and disseminate statements has gone from soapboxes to worldwide broadcasts overnight. Today, if I want to start a campaign against my nemesis, Joe Jones, I have a whole array of tools to make statements against him. In the course of an afternoon, I can start a series of social media posts that, if I am artful, will get picked up by other users, promoted by social media algorithms, and eventually covered by legacy media. If I post that I heard Joe Jones is eating his neighbor's pets, I might even have a presidential candidate repeating it by the end of the week. In this respect, I would turn back to Marshall McLuhan. The message is the medium. What McLuhan meant by that is that the nature of the medium shapes and forms the message. Why don't we have people reading books on television? Because the demands of television are different than a book. In social media, the key is that truth is not the hallmark of the medium. Social media posts care about viralness. Is it short, watchable, and fun? Does it trigger certain dopamine responses? If yes, then it will spread. Think about your social media threads, your Instagram posts, the tweet, the TikToks, the Facebook Reels. These all have rules for success, and none of them are truthfulness, research, or thoughtfulness. Here's where things get thorny. For some people, social media is becoming the public forum. Think about where you get your information from and where you go to speak your truths. It's not on the street corner. At what point does a private actor like X or Facebook stop being a private company and start being a public forum where users can expect some form of public protection? As more and more of our lives move online, the more central these platforms become. Right now, these companies apply private, internal content regulations. But as we can see, they can vary wildly from platform to platform and from owner to owner. At what point does a private service become a public forum? In Knight First Amendment Institute at Columbia University versus Trump, a Second Circuit decision joined by the late Judge Hall, the court ruled that when public officials use social media to communicate with the public about their work, then the account will become a public forum. Individuals have a right to follow, post their comments, and a public official is limited by the First Amendment from blocking or taking comments down. This is a fact-specific inquiry, and it only lasts as long as the account holder remains in office or affiliated with the government and uses the account as part of their public office. Thus, if Joe Biden wants to open a Twitter account in his name but only posts to talk about his large and extensive collection of Cabbage Patch dolls, the court is unlikely to deem the account public. But Knight First Amendment Institute does not answer the question that technology suggests. When people use social media as the public square, will there come a point where so many government services and communications flow through the site that its owners will have First Amendment obligations? Commentators on both the left and right have envisioned such a day, and we need only look to the issues of utilities, telecommunications, and healthcare to realize that as use increases and reliance on these forums crystallize, there will either be a public expectation or a tipping point of investment where the forum evolves into a public sphere for purposes of the First Amendment protection. The last topic that I want to cover very briefly is libel and Section 230. One way to conceive of libel is to think of it as a private right of action that applies where First Amendment limits regulation. So while the government may not police certain speech, private actors who are harmed by false or misleading information can seek damages for the harm caused. This liability extends not only to the speaker of libelous speech, but also to the publisher of such. Here's where it gets complicated. 47 U.S.C. Section 230 says that no provider or user of interactive computer service shall be considered a publisher or speaker of any information provided by another. What does it mean? It means that most internet providers, Facebook, Twitter, Reddit, Truth Social, and more, I'm looking at you, cannot be held liable for material that others publish on its platforms. This made a whole lot of sense in the early days of the internet, where cases like Stratton Oakmont Inc. versus Prodigy, a New York trial court decision, threatened to make early internet providers responsible for content provided to their bulletin boards. But Section 230 was a response to protect this emerging service, and 30 years later, it's hard to argue with the progress it has enabled. But companies are interacting with data differently. Platforms like Meta do not simply provide passive forums to permit users to post and discuss. Data is the currency of the realm, and algorithms are the comptrollers. The Third Circuit ruled last month that TikTok's algorithms are TikTok's own first-party speech, and thus fall outside of Section 230's liability shield for the publication of third-party speech. In Anderson versus TikTok, this means that platform providers can have liability if their recommendations are shown to lead to libelous speech. This is big, but it reflects a growing frustration. While the old publisher's liability model did not work for internet platforms in its early days, neither does Section 230 allow victims to seek compensation or enjoy robust policing of harmful information. This concern has only grown with the shifts in how these companies interact with the data, and the relationship is changing. The Anderson case suggests how at least one court is looking beyond Section 230 to the shifts in technology. So with that, I leave you with this warning. We're all narcissists, but unlike our Greek friend, the klaxons have sounded. We can and must be aware not only of the facts of technology, but its impact and the changes that it brings. The good news is that we already have the tools to deal with these challenges. In each of these examples, the challenge has not been to come up with a potential solution, but to apply the right concepts to the challenge and to recognize how the technology is being used and what type of extension it represents. If we as courts and lawyers can do this, then these intractable issues start to look less so. Thank you.
With your permission, I will use the podium and PowerPoint I can't think unless I'm standing on my feet walking around a little, so let's get started. So I would like to come at some of the same issues that have been raised already, but from a slightly different perspective. So why are we here today? We're here purportedly to celebrate the birthday of our Constitution. It is the 238th birthday of our Constitution. We ought to be very proud of the achievement that is represented by the Constitution. It's the first national Constitution ever written and adopted, dedicated to the idea that at a national level, people are capable of governing themselves through what we call democratic self-government, the very first Constitution. It's provided the model for virtually every national constitution that has been adopted since. And it is by a long shot the longest serving constitution in the world. You know what the average lifespan of a national constitution is in the world? 17 years. So we're talking about really something that is a remarkable achievement. I think when we think about the Constitution, say, what are we celebrating? The American Constitution, it's important to remember that we're not just celebrating the original document adopted by the framers. That still provides the basic framework for governance in this country, but it has been changed substantially by subsequent amendments. The Bill of Rights, the first 10 amendments, profoundly changed our understanding and the importance of our national Constitution. The Civil War amendments adopted after the Civil War, 13th, 14th, and 15th, extremely important, in particular the 15th Amendment, for the first time making the recently emancipated slaves and black citizens members of our political community. The 19th Amendment, only adopted in 1920, suddenly expanded the polity to include women participants. Those are just a few. There are others as well, but those are major changes to the nature of democracy in this country. Suddenly, we have, instead of a world that the framers lived in which the only people who participated in democratic self-government were white, male, primarily property owners, to a world in which you have an incredible variety of participants actively playing a role in democratic self-government. So the Constitution, both as originally framed and as amended and as interpreted, and all of the traditions and commitments that have followed through time, do represent something of which we ought to be really proud, and that's why we're here today. Now, what happens next? Now I want to complicate our lives just a little bit. Help me understand this. A poll that was taken just this year, conducted by Georgetown University, found that 81% of voters believe democracy is threatened in this country. New York Times Siena College poll found that a majority of people think that our institutions are in serious trouble and need serious reform. Another poll, ABA poll, found that 74% of the respondents thought that democracy today was weaker than it was just 5 years ago. And I'm sitting there and I'm saying, look, we've got this robust democracy with all these different participants. Why, you have to help me with this question, why do people feel that democracy is threatened in this country? What's the answer to that? What's going on? Okay, I'm just going to ask you, because we don't have time to get into sophisticated answers. There are a lot of answers. Some of them have already been addressed today. One of the concerns is that new technology may be making it difficult for democracy to work the way it did for the framers. Problems of misinformation spread on the internet, the use of AI to generate fake images and fake news. What is it, the polarization of the body politic? Is that what is causing people to think democracy is threatened? Is it that legislation at the national level seems to have encountered a kind of paralysis? We really don't see Congress adopting laws in the way I think our framers imagined they would. Maybe these polls, all of which were taken before July of this year, reflect the fact that the particular candidates for president at that point in time suggested that American democracy is not in good shape, and we can't discount that. But I want to raise the question whether the Constitution itself may, in part, be responsible. So help me think about that just a little bit. Okay, we start off with this beautiful, beautiful document, but is it up to the task of providing us with a vital, meaningful, robust democracy in the modern context? I'm just going to raise the questions. You probably have some ideas. Why do people feel that democracy is threatened today, this year? Okay, one possibility. What about the U.S. Supreme Court? Is that part of the problem? Do you think there ought to be term limits for the justices on the Supreme Court? We can come back and discuss that, but I'm just interested in that. We've got some room to change the composition of the court, but do you think there ought to be term limits for the justices? Okay. Here's a statistic that might interest you. From 1787 to 1970, the average tenure of Supreme Court justices was 15 years. For those appointed since 1970 who have left the bench, the average tenure was 26 years. For many of the current justices, the average tenure is likely to be 30 years. Is that a problem? Does that somehow raise questions about whether or not democracy is in a good shape in this country? What about the Electoral College? Does that contribute in part to our sense that democracy is not functioning very well? What do you know about the Electoral College and its impact on U.S. presidential elections? Twice in this century, the person who was elected as President of the United States was not the winner of the national popular vote. He was elected by the Electoral College, but not by the national popular vote. In fact, in one case, lost the national popular vote by more than 5 million votes. So it's the Electoral College and the way that operates in our political system, undermining our confidence in our democratic system to function as it should in the modern context. Could have happened also in 2004 and 2000. This last election, I don't have it up there correctly, but the outcome was decided by 41,000 votes in 3 battleground states. That easily could have gone the other way, and we could have had another president who was elected not by the people of the United States, but by the Electoral College. What about the amendment process itself? The framers wanted to have an amendment process that was at least not easy to comply with, but here are the requirements. There are other ways to amend the Constitution, but this is one way. That you need to have, first of all, a proposal that's adopted by 2/3 vote of both houses. How likely is that today? Okay? And then it goes out to the states and has to be approved by 3. How likely is it that we can expect meaningful amendment of the Constitution through this process with the restrictions that are in the Constitution itself? So I just want to raise that question with you today. To what extent are our misgivings about the health and well-being of our democracy in part a function of constitutional restrictions themselves, and if they are, what should be done about it. So I ask you, you may have your own views, but if you could make one change in our Constitution without having to worry about going through the cumbersome amendment process, but just had a magic wand and could make one change to make democracy work better in this country, what change would you make? So I want to conclude with this character, Thomas Jefferson. I should have this in front of me so I could read it. Oh no, this is not going to work.
Here, you know what? Yeah.
Okay, there we go. Thanks, yeah. Some men look at constitutions with sanctimonious reverence and deem them like the Ark of the Covenant, too sacred to be touched. They ascribe to the men of the preceding age a wisdom more than human and suppose that what they did to be beyond amendment. Okay. I'm certainly not an advocate for frequent and untried changes in laws and constitutions, but I know also that laws and institutions must go hand in hand with the progress of the human mind. We might as well require a man to wear still the coat which fitted him as a boy, as to be content sticking with a constitution that was adopted by different people in an age and a world very different from our own. So I'll leave you with that question then. What change would you make in our constitutional system if it was in your power to do so? Thank you.
Yeah, sure.
Well, thank you very much. That was very informative and evocative. I open it up for questions. Anyone have questions for the panel members?
Or comments?
Or comments? Yeah, yes.
Thank you. It was super informative. I very much enjoyed it. This was a great Constitution Day. Oh no.
Yeah, please.
Okay.
I can yell if I can do it. Yeah, was not prepared. I forgot. I said thank you. I really appreciated it. It was super informative and made a great Constitution Day. It's always good to see what we can change and like look from different perspectives because, you know, coming from like a newer time, you know, like I'm only 24 and I don't have any legal experience. So it's like interesting to look at it from that perspective, essentially. So thank you.
I don't know.
I have a question for, I believe it's Judge Richardson. Could you please elaborate on what you said at the beginning of your presentation regarding Narcissus and why you think that social media is an extension of the self?
Well, so this goes back to a little bit of thinking about Marshall McLuhan, and who was for those who aren't familiar with him, he was a Canadian English professor gone wrong, who got obsessed with technology, and in the mid-20th century wrote a number of books about what technology was, trying to understand it. One of his seminal works is Understanding Media, in which he posits this idea that all technology is but an extension of us. The wheel is an extension of our feet, language is an extension of our mind, but everything that we create with technology is ultimately an extension from ourselves. So it's not as if we create anything new under the sun. We just create ways of doing what we've done better, and as a result of doing it better, it creates changes. It's a cascading effect. It's a very, so it's not like, well, I have a wheel now that I can walk really fast. It's that having that fast transportation changes the way we can get from place to place. We can live further apart. We can, and as by living further apart, we can own more land because we can have bigger estates, and that can have these cascading effects. But it ultimately comes back to the technology itself being an extension of ourselves. And so for him, he was a big proponent of different stories and myths. Edgar Allan Poe's The Descent into the Maelstrom was a favorite of his. But the myth of Narcissus being that sort of idea that Narcissus falls in love not with himself in his mind, but with this beautiful image. And so when we look into social media, in a lot of ways, we're looking back at ourselves. We're amplifying these sort of internal monologues, these person-to-person conversations that we have, but we do so in a way that have these cascading effects and these changes. But it's the idea that the solutions really lie, in a lot of ways, inside of the idea that this always generates from the self. So it's not as if aliens came down and brought this new thing to us. We created it. It is from ourselves. So that's in a nutshell.
The gentleman in the back there.
Hello, esteemed panel. Thank you all. My name's Avery. I'm from Houston, Texas. I spent the last 4 years of my life working in elections down there, helping people vote, which in my mind is, of course, the synthesis and perhaps the inception, the ultimate realization of free speech in this country, being able to condense all of your political views into that expression. My question, though, is in my work, I did see threats to our democracy. In fact, me and my family personally had been threatened. And people stand outside poll locations there, armed in some cases, and it is intimidating to voters to go there. But even further, people are violent, and there are people in our politics that speak to incite that violence, but are not held accountable to that. And I point particularly to a case in El Paso, Texas, when a young man drove across the state and began shooting people at a Walmart. So my question is, should we as a society accept that when that violence is happening? Or do you feel, as I feel, that when people's speech is used to oppress people, it is no longer free? And I guess my question is, should we accept that there are political figures that are pointed to and used as justification for that violence? And should they be sanctioned in some way?
Well, that's an easy question. Anyone want to take it?
Go ahead, Bill. No, it's all yours.
We can order them to do it.
Yeah.
Are you remanding it to us?
Yeah.
Or Professor?
Well, you know, it's interesting from what Justice Eaton was telling us that our First Amendment law is very libertarian, and it says even if you advocate violence, unless you advocate imminent violent action, that speech is protected. And you're raising the question of whether in our society today we can continue to afford the luxury of saying you're free to incite violence as long as you're not inciting some imminent violent or lawless action. The question is raised, I think it's a fair one, Justice Eaton, of whether that we can continue to afford that, especially in the world of social media and the internet. Yeah.
I think it's a great question. If I had the answer, I wouldn't be sitting here.
You know, one of the concerns I've got about our current state of affairs is the proliferation of anonymous speech. People who not only can speak without any self-identification, but actually what we are seeing more and more of, I guess, is speech that's taking place by avatars or simulated individuals, the speech of the president that is created through technology. All of that, I think, is quite disturbing. I don't know whether, and it seems to me that it is in tension with what the original founders were talking about. I mean, John Adams talked about speech in the public square. That's not an anonymous speech. That is people standing up for their point of view, making statements in that regard, but not by hiding behind or finding a way to create anonymity about what they are saying. Incidentally, Texas, as I'm sure you probably know, elects judges. We don't do that here in Vermont, and most New England states do not do that either. The election of judges and the speech that takes place around the campaigning for judicial seats is something that I think is very, very interesting, something I'm glad we do not have to engage in here, but is certainly a different variety of the kind of speech that I think most of us would be comfortable with.
If the threat of lawlessness needs to be imminent, how do you measure that when a message can circle the globe in a relative instant? What's the value of the imminent prong anymore?
So maybe we ought to come, oh, there's a question.
Thank y'all kindly.
Alfonso? Okay.
Thank you again for the presentation. And I want to ask about this concept of imminency. How do you measure that? And I would note that even back when we were talking with the public square, there were folks back then still had to deal with rumor, or folks that published under pseudonyms or nom de plumes to attack or to disparage their political rivals. So anonymity is not something new. It's definitely something that existed before. I think that a disparity in terms of how the First Amendment law protects or enforces free speech. There's disparity in those that say are of the hegemonic class or that look, say, white, and those that are not. In terms of how do you measure imminency? For example, if you are a black individual and you move to Vermont and you're living in Vermont and someone puts up a burning cross in front of your property or puts pamphlets with swastikas or whatever. What the question is this calling for imminent violence? And I think the case law has been that no, it's not. But for the family and for those of that particular population, that is a constant and real threat that they have to deal with. And so I think it's Justice Jackson, not the current Justice Jackson, but the older Justice Jackson, in his dissents in terms of free speech, says that the U.S. government, or the U.S.'s approach has been to sacrifice public order to this concept of unfettered free speech. And I think that that is not right.
What about true threats?
Let me just complicate things just a little bit by saying that one area of speech that is not protected by the First Amendment is advocacy of unlawful action, which is what Justice Eaton was talking about. But there's another area that might provide some purchase for a family in that situation, and it's called true threats. True threats are also not protected under the First Amendment. If you say or do something that would make a reasonable person feel that they are threatened with injury, harm, and you do so with reckless disregard of whether it might make a reasonable person feel like they are in danger of being physically harmed, that speech is not protected either under this other category called true threats category, just for what it's worth. Okay.
If I can put in a plug as well, I think we have to be careful, and I almost excised it, but I kept the section on libel in my presentation because I don't think we cannot forget that there is private actions that individuals can take when harms have been rendered by speech. And part of what I think is really important about Anderson versus TikTok is that we're starting to look at a post-230 world where there are potential liabilities for the spread of this type of, where people are encouraged through these algorithms to, to use an Orwellian phrase, hate on something. And so I think, it's not always necessarily a First Amendment that's going to come in and save the day. Sometimes it's going to be through private action because the harm is really a private harm.
There's a woman in the back.
Thank you all for joining us and sharing your insights. This question is for any or all of the panelists. If there was one thing that you wish every single American would know today about the Constitution, what would that be?
That it's a participatory democracy that we live in. We live in a democratic union that calls on us to exercise responsibility in the form of voting, in the form of understanding, seeking to understand issues. That this is not a passive act that we as individual members of this democracy can maintain without creating great risk to the institutions of democracy themselves. That's what I would say. So,
I just saw two more hands, if I could indulge you. A woman in the back and a gentleman in the front row.
and then there's pizza, so we can.
And a beautiful cake, a birthday cake for the Constitution, so.
Hi, sorry, I have a little bit of an allergy, so if you guys can hear me, okay. But my question for the panelists is, do you all, or just let me know your guys' opinions, do you believe that sections or amendments in our Constitution have been abused, overused, or taken advantage of? For example, the relation of the 13th Amendment into the school and prison pipeline and how that's led to mass incarceration of minorities in this country.
I think there are tons of examples of the abuse of constitutional provisions. I don't think that is something that any of us should deny. I think we live in an imperfect world. We're human beings, and I think that the struggle that we need to face up to, similarly to what my answer was a few moments ago about the one thing that I think people need to understand is the responsibility that we all carry to honor the principles that are at the foundation of the country. And those principles and I think many people are very committed to. But in the execution of those principles, it is something that we need to continually work towards perfecting because we are not, we are not perfect in the way in which we execute. I would tell you the same thing about the courts. I can't tell you how much time that we spend, my friend here, Duke Eaton, and I, and other colleagues on the court, and Terry Corsones, how much time we spend on trying to improve access to justice in this state of Vermont, just in this state of Vermont. And we are not perfect at it by any means. There are lots of holes in the fabric of the court system in this state. And I'm not proud of saying that because I'm responsible. And I feel that responsibility very strongly, but it's not something that has a cookie-cutter answer. It is something that we need to recognize, we need to acknowledge. We have a diversity, equity, and inclusion project that our court, has instituted as of about 2 years ago now, that is ongoing, and we are striving to improve the composition of our judges, of our bench, the composition of the people who work in the system, and the way in which we are delivering justice in the state that aspires to these fundamental principles of equality, of equal justice under the law. This is something that, I mean, you ask a very, very important question, and it's an important thing for us all to focus on how hard we need to work in order to try to achieve and do better.
And I would add to that, increasing the diversity of the bar and of jury pools.
Yeah.
Right. And finally, I think there's just one more gentleman.
Okay.
Thank you.
Hi, thank you so much for this. Was really, really interesting, really important. I know everybody wants to eat pizza, so I'll be really quick. So, Professor Peter, you make us a question, but I want to return that question to you. If you could change one thing, what would you change? But to be fair, I'll tell you my answer. So I'm not a U.S. citizen, and I'm sure you guys don't want me in charge of amending your constitution. But if I could change something, that would be probably to include tools or actions that are effective, fast, and urgent to protect our planet and nature and animals as well. So yeah, probably maybe recognizing nature as a subject of rights. I don't know. But yeah, I want to know your opinion, and if anybody else in the panel could. Thank you.
Okay, there's a lot of interest in at the state level and to a certain extent at the federal level at including of changing the Constitution by adding a provision protecting the rights of things other than ourselves, that is animals, nature, whatever. Those constitutional provisions have had some practical effect. They also are difficult in terms of our traditional operation of the judicial system, because you say, well, who would represent the animals or the trees or the future generations? What sort of relief could a court provide in case you claim, for example, that America is not doing everything it could do to avoid climate change, that Congress? So they're problematic in implementation, but there's a great deal of sympathy and interest right now in adding to Constitution's provision, protecting the rights of nature.
If I may, during this discussion, feel free to help yourself to pizza and cake while folks are asking questions and milling about. But I didn't mean to interrupt.
No, I'm sorry. I know it has some people, some problems, but I wasn't asking you that.
I know what you were asking me, and I was avoiding your question.
Well, I'm sure the panelists will be eager to answer any of your questions if you get an opportunity to speak with them over pizza and cake. Thank you very much.
Thank you, Judy.